Now, in our previous video, we have discussed from order 1 to order 6. If anybody is interested and want to follow the entire list, then he can go to the channel playlist from the live telecast. One can find the previous orders and discussion on previous orders. Now, in this video, we will discuss about order 7 of the civil procedure code. Okay, now order 7 deals with the plaint. Now order 7 rule 1 says particulars to be contained in a plaint. This provision is very important, and from this provision and this specific section you will get questions in preliminary as well as in written examination of your whether it is judicial service or it is a law officer exam. So please be very careful and keep your bare act with you. Please, it is a request, keep your bare act with you. So order 7, that is plaint of civil procedure code 1908. Now rule 1 says particulars to be contained in a plaint. The plaint contains the following particulars. What? B, the name, description and place of residence of the plaintiff and place of residence of the defendant so far can be ascertained. D, where the plaintiff or the defendant is a minor or a person of unsound mind, a statement to that effect. E, the facts constituting the cause of action and when it arose. So the facts on which the cause of action or which assuming which the cause of action arises and when it arose. Both the things must be mentioned. F, the facts showing that the court has jurisdiction. G, the relief which the plaintiff claims. And H, where the plaintiff has allowed a set off or relinquished a portion of his claim, the amounts so allowed or relinquished. And I, a statement of the value of the subject matter of the suit for the purpose of jurisdiction and of court fees so far as the case admits. So these are the essential requirements of a plaint. If anyone of you have seen a copy of a plaint, then all these things you will find in the generally in the first page, where the plaintiff number of plaintiffs and defendants are less. Suppose one person versus one person case. In such a scenario, you will find all these things in the first page of the copy of plaint. Please try to have a look at a copy of any of the plaint if you have anyone known in your connection who is a practicing advocate in civil side. Go to him and ask for a copy of plaint. Then you can see that. Now coming to rule 2 in money suits. Now the above rule is for general. Okay, rule 1 is for general suits. Now specifically rule 2 says about money suit. What does it say? Where the plaintiff seeks the recovery of money, the plaintiff shall state the precise amount claimed. That is, a certain sum must be subject matter of a money suit. So the precise amount claimed, but where the plaintiff sue for mean profit or for an amount which will be found due to him on taking unsettled accounts between him and the defendant, or for movables in the possession of the defendant, or for debts of which the value he cannot after the exercise of a reasonable diligence estimate, the plaintiff shall state approximately the amount or value sued for. Okay, so first of all the claim must be specified, or precise amount must be claimed in the plaint or mentioned in the plaint in case of money suit. But if the precise amount cannot be ascertained, or if the amount or principal amount is precise but interest, but mean profit, or for an amount which will be found due to him on taking unsettled accounts between him and the defendant, in these scenarios approximate amount or value sued for must be mentioned in the plaint. So for commercial courts there is a provision, and that is rule 2a, where interest is sought in the suit, where the plaintiff seeks interest, the plaint shall contain a statement to that effect along with the details set out under subrule 2 and 3. Okay, so subrule 2 and 3, we are just coming to 3, and here subrule 2 of rule 2a says, where the plaintiff seeks interest, the plaintiff shall state where the plaintiff is seeking interest in relation to a commercial transaction within the meaning of section 34 of the Code of Civil Procedure 1908. And furthermore, if the plaintiff is doing so under the terms of a contract or under an act, in which case the act is to be specified in the plain or on some other basis and shall state the basis of that, and pleading shall also state, number one, the rate at which the interest is claimed, number two, the date from which it is to be claimed or it is claimed, C, the date to which it is calculated, and D, the total amount of interest claimed to the date of calculation and daily rate at which interest accrues after that date. Okay, these are the things specified for commercial courts. This section is only for commercial courts, and this is for money suit, and this is in general. Okay, so rule 1 is general, particulars to be contained in a plain, 2 is for money suit, and rule 2A for commercial courts. These are the specific provision. You in preliminary examination it may be asked for commercial court where is the provision to provision of the essentials to be mentioned in a plain. Now in that case you have to answer 2A. Okay, rule 2A of order. Now rule 3 of order 7 says where the subject matter of the suit is immovable property. Okay, now where the specific subject matter of the suit is immovable property, the subject matter of the suit is immovable property where the plaintiff shall contain description of the property. In case of immovable property, in case of money, you must mention the amount claimed, precisely the amount claimed. In case of immovable property, that is rule 3 of order 7 says the plain shall contain a description of the property sufficient to identify it, and in case such property can be identified by boundaries or numbers in a record of settlement or survey, the plain shall specify such boundaries and numbers. These are as a representative. Now, if the plaintiff sues in a representative capacity, which have been discussed under order 1 rule 8 of the Code of Civil Procedure in our previous video. Now in that case, where the plaintiff sues in a representative character, the plain shall show not only that he has an actual existing interest in the subject matter, but that he has taken steps, if any, necessary to enable him to institute a suit concerning it. Okay, now rule 5 says defendant's interest and liability to be shown. The plain shall show that the defendant is or claims to be interested in subject matter and that he is liable to be called upon to answer the plaintiff's demand. Okay, now in the plaint you must specifically raise this issue that the defendant is or claims to be interested in the subject matter and that he is liable to be called upon to answer the plaintiff's demand. Okay, now rule 6 of order 7 says grounds of exemption from limitation law. This is very important. You have you may have read about the Limitation Act. We will discuss it also. So where the suit is instituted, rule 6 order 7, where the suit is instituted after the expiration prescribed by the law of limitation, the plain upon which exemption from such law is claimed. So where the suit after the expiration of the period prescribed by law for limitation. So generally under the law of limitation, after the section 5 of the limitation law says that the condonation of delay, but that section 5 is not applicable to suits. Please remember this thing. Section 5 is only applicable to appeals and applications other than the application under order 21. Okay, that is related to execution. So section 5 is only applicable to those matters for which the schedule or the time limit given under the Limitation Act is very short. But if we go through the provision of section 6, 7 and 8 of the Limitation Act, where the matter of disability has been dealt with. Now in such cases a suit can be instituted even after the long period mentioned in the Limitation Act. So here we are dealing with those suits where the suit is instituted after the expiration of the period prescribed by the law of limitation. The plaintiff shall show that the ground upon which exemption from such law is claimed. So you have to mention, or plaintiff have to mention the exact provision under which he is claiming this benefit. And that provision may be section 6 or 7 or section 8 of the Limitation Act, whatever it may be. Okay, provided that the court may permit the plaintiff to claim exemption from the law of limitation on any ground not set out in the plaint if such ground is not inconsistent with the ground set out in the plaint. Now, after instituting the plaint, the court, if the circumstances arise in such a manner that there is a valid ground available to the plaintiff, but the plaintiff has not been sought for the ground. Now, in such a case, the court, what can the court do? The court may permit the plaintiff to claim exemption from the law of limitation on any ground not set out in the plaint. But in that case, there is a catch, or there is a consequence. What is the proviso? If such grounds is not inconsistent with the grounds already set out in the plaint. Okay, only in that case the court may permit the plaintiff to claim exemption from the law of limitation. Now, Rule 7 of the Order 7, Rule 7 of the Code of Civil Procedure. Now, relief to be specifically stated. Now, every plaint shall state specifically the relief which the plaintiff claims, either simply or in alternative, and it shall not be necessary to ask for general or other relief which may always be given as the court may think just to the same extent as if it had been asked for, and the same rule shall apply to any relief claimed by the defendant in his written statement also. So, Order 7, Rule 7, relief to be specifically stated. Now, in this case, you have to remember that this is not only related to the relief claimed by the plaintiff, this is also referring to the reliefs claimed by the defendant in his written statement if the defendant files a counterclaim or sought for any set off. Now, in such a case, so, every plaint shall state specifically the relief which the plaintiff claims, either simply or in alternative, and it shall not be necessary to ask for general or other relief which may always be given as the court may think just, to the same extent as if it had been asked for. So, general reliefs are always given, or one need not to specifically ask for those reliefs, and the same rule shall apply to any relief claimed by the defendant in his written statement. Okay. Now, Order 7, Rule 8 says, relief found on separate grounds. Where the reliefs are found on separate grounds, where the plaintiff seeks relief in respect of several distinct claims or cause of action founded upon separate and distinct grounds, they shall be stated as far as may be separately and distinctly. So, if the relief is found on several or distinct claims, the reliefs must be claimed as far as practicable or as far as possible separately and distinctly. Now, Rule 9 of Order 7 says, procedure on admitting plaint, concise statement. Now, what will be the procedure on admitting plaint? The plaintiff shall endorse on the plaint or annex thereto a list of documents, if any, which he has produced along with it, and if the plaint is admitted, shall present with such time as may be fixed by the court or extended by it from time to time, as many copies on plain paper of the plaint as there are there are defendants. So, as many defendants are there, you have to file that much copies of the plaint on plain paper, unless the court, by reason of the length of the plaint or the number of the defendants or for any other sufficient reason, permits him present a like number of concise statement of the nature of the claim made or of the relief claimed in the suit, in which case he shall present such statements. Okay. So, general rule is that you have to file the copy of the plaint according to the number of the defendants who will be served, and those copies will be served with the summons to that defendants. Okay. Now, if the number of the defendants are numerous and the court thinks that it is not necessary to serve everyone with the same copy of the plaint, now in such case, unless the court, by reason of the length of the plaint or number of the defendants or for any other reason, permits him to present like a number of concise statement of the nature of the claim made or of the relief claimed in the suit, in which case he shall present such statement. So, in case of numerous defendants or lengthy plaint, the court may permit the plaintiff to file a concise statement. Now, Rule 1A, this is under, that is Subrule 1A, Rule 9, Subrule 1A. Okay, the plaintiff shall, within the time fixed by the court or extended by it under Subrule 1, pay the requisite fee for the service of summons on the defendant. So, the charges of the service of summons must be paid or have to be paid by the Plaintiff. Okay, the plaintiff shall, within the time fixed by the court or extended by it under sub-rule 1, pay the requisite court fee for the service of summons on the defendant. Now, sub-rule 2 says where the plaintiff sue or the defendant or any of the defendant is sued in a representative capacity, such statement shall show in what capacity the plaintiff or the defendant sues or be sued. So, if the suit is a representative suit, or the defense is a representative, defendant is representing or defending the suit in a representative manner, then the statement, the concise statement must show the nature of the suit. Okay, now this is sub rule 3 of rule 9 of order 7 says the plaintiff may by leave of the court amend such statements as so as to make them correspond with the plaint. So if it is necessary to amend the plaint to correspond, which will correspond with the, if there is a discrepancy between the concise statement and the plaint, then there is an option to the plaintiff to ask for a leave of the court to amend the concise statement, and the court generally grants that permission. Okay, now sub rule 4 of rule 9 says the chief ministerial officer of the court shall sign such list and copies or statements if on examination he finds them to be correct. So if all the requirements of the plaint and the documents and the copies or the concise statement, everything was okay, is okay, then the chief ministerial officer of the court will sign those statements or copies. Okay, now return of the plaint. This is very important, order 7 rule 10, where the provision is mentioned about the returning of the plaint. Return of plaint, what is that? Now rule 10 sub rule 1 says subject to the provision of rule 10a, subject to the provision of rule 10a, which will read later, the plaint shall at any stage of the suit be returned to the, be presented to the court in which the suit should have been instituted. Okay, now if the court at any stage of the proceeding, the court finds that the plaint is presented to, is not presented to a proper court, or the proceeding going on in the court which do not have any jurisdiction to entertain the plaint, then it at any stage, the plaint shall at any stage of the suit be returned to be presented to the proper court in which the suit should have been instituted. The explanation: for the removal of doubt, it is hereby declared that a court of appeal or revision may direct, after setting aside the decree passed in a suit, the return of the plaint under this sub-rule also. So if an appellate court or a court of a revision, that is a high court, finds or set aside a decree passed in a suit, then that court can also order the return of the plaint under this sub rule. Okay, now rule 2, this is very important, I mean rule 10 sub rule 1. Okay, very very important. Sub rule 2, procedure on returning plaint. So if the plaint is returned, what will you do? What will be the steps that have to be taken by the plaintiff? Now on returning a plaint, the judge shall endorse thereon the date of its presentation and return, the name of the party presenting it, and a brief statement of the reason for returning it. So while returning, the judge shall endorse thereon the date of its presentation and return, and the name of the party presenting it, and a brief statement of the reason of returning it. Okay, now rule 10a says power of court to fix a date of appearance in the court where the plaint is to be filed after its return. So now the court returning the plaint, or the court which do not have the jurisdiction to entertain the plaint, and that's why it is returning, have also the power to fix a date to appear before the proper court. Okay, this is also important rule. Let's see. Rule 10a sub rule 1 says where in a suit the defendant has appeared, the court is of the opinion that the plaint should be returned, it shall before doing so intimate its decision to the plaintiff first of all. And sub rule 2 says where an intimation is given to the plaintiff under sub rule 1, the plaintiff may make an application to the court A specifying the court in which he proposes to present the plaint after its return. Okay, now then B, praying that the court may fix a date for the appearance of the parties in the said court, and C, requesting that the notice of the date so fixed may be given to him and to the defendant. This is a very interesting practical aspect of practice. where now this provision is only applicable where the defendant has also appeared. Okay, see, you see here it is said that where sub-rule 2, where an intimation is given to the plaintiff, oh I'm sorry, sub-rule 1 says where in any suit after the defendant has appeared. Okay, now this process can be done only after both the parties have appeared in the matter. Okay, now coming to sub-rule 3, where an application is made by the plaintiff under sub-rule 2, the court shall, before returning the plaint, and notwithstanding that the order of return of the plaint was made by it on the ground that it has no jurisdiction to try the suit, A, fix a date for the appearance of the parties in the court in which the plaint is proposed to be presented, and B, give to the plaintiff and to the defendant notice of such date of appearance. And sub-rule 4 says where the notice of the date of appearance is given under sub-rule 3, clause A says it is not necessary for the court in which the plaintiff is presented after his return to serve the defendant with a summon for appearance, because he has already been appeared. Okay, so it is not necessary for the court in which the plaintiff is presented after return to serve the defendant with a summon for appearance in the suit, unless that court, for reasons to be recorded, otherwise directs. And B, the said notice shall be deemed to be a summon for the appearance of the defendant in the court in which the plaintiff is presented on the date fixed by the court by which the plaintiff was returned. Okay, now this the notice that the intimation will be treated as a summon for the proceedings of the second court or the proper court or the court in which the plaint has been filed after returning from the court which do not have any jurisdiction. Just follow through the procedure, visualize the proceedings, just visualize the proceedings. It's very simple and very interesting. Civil proceedings are very interesting. Now, sub-rule 5 says where the application made by the plaintiff under sub-rule 2 is allowed by the court, the plaintiff shall not be entitled to appeal against the order returning the plaint. So, sub-rule 5 of rule 10A says where the application made by the plaintiff under sub-rule 2 is allowed by the court. That means what is sub-rule 2 says? We have just read that sub-rule 2 is procedure on returning plaint. On returning a plaint, the judge shall endorse there on the date of its presentation and return of the party and in brief statement for the reason. Where an intimation is given to the plaintiff under sub-rule 1, the plaintiff may make an application. This is the application we are talking about. The plaintiff may make an application to the court for what? Specifying the court, praying for a fixed date, and requesting that notice to be given to the defendant. These are the causes. Now, in this, after this, now rule 5 says where the application made by the plaintiff under sub-rule 2 is allowed by the court, the plaintiff shall not be entitled to appeal against the order returning the plaint. Okay, now you cannot appeal against your own you cannot appeal against an order which for which you have applied. You personally applied for that order, and when that order is given, you cannot file an appeal against that order. It's as simple as that. Now, rule 10b, what rule 10b says? Power of appellate court to transfer suit to the proper court. Now, rule 10b says power of appellate court. Rule 10a, what we have read in rule 10a, power of court. Say power of court to fix a date of appearance in the court where the plaint is to be filed after its return. So, this is the court which for either defect of jurisdiction or any other cause of a like nature is unable to entertain the suit. This is the court under rule 10a. But in rule 10b, power of appellate court to transfer the suit to the proper court. What has been said? Now rule 10b of order 7, rule sub-rule 1. Okay, where an appeal against an order from the return of the plaint, the court hearing the appeal. Where an appeal against an order for the return of the plaint, the court hearing the appeal confirms that order, the court of appeal may. Now, if we have just read that if the plaintiff applied for the return of plaint, he cannot file an appeal. But if the plaintiff have not applied for the return of the plaint, and the court, on the basis of its own best sense of judgment, returns the plaint, now in such a case, the plaintiff is entitled to file an appeal against that order. As simple. So, where on an appeal against an order for the return of the plaint, the court hearing the appeal confirms such order, the court of appeal may, if the plaintiff by an application so desires, while returning the plaint, direct plaintiff to file the plaint subject to the provision of the Limitation Act 1963. Okay. in the court in which should have been instituted. Okay, so the court may direct the plaintiff to the court to which the suit should have been instituted, subject to the provision of the Limitation Act. Okay, if the Limitation Act does not raises any bar, then the plaintiff may institute the suit to the proper court. Now, whether such court is within or without the state in which the court hearing the appeal is situated. Now, the appeal, the court hearing the appeal against the order of the returning of the plain, it is immaterial for that court whether that court is within or whether such court is within or without the state in which the court hearing the appeal is situated. That means it is not necessary for the court hearing the appeal of return of plain to be within the jurisdiction. Okay, and fix a date for the appearance of the parties in the court in which the plaint is directed to be filed, and when the date is so fixed, it shall not be necessary for the court in which the plaint is filed to serve the defendant which to be recorded, otherwise digest. Okay, now in these kinds of proceedings, the plaintiffs will generally, the defendants will not generally be served with the summons again for when the plaint is presented to for the second time in the proper court, unless the court otherwise directs. So that means the court always have a discretionary power to intimate the defendant in subsequent or in separate ways. Okay, now sub-rule 2 says direction. The direction made by the court under sub-rule 1 shall be without any prejudice to the rights of the parties to question the jurisdiction of the court in which the plaint is filed or try the suit. Okay, now if in which the suit have been directed to have been filed, now this direction or this order is without any prejudice to the rights of the parties to question the jurisdiction of the court in which the plaint is filed or to try the suit. Okay, now the court which has decided the appeal against the returning of the order of the returning of the plaint and dismiss the appeal and confirm the order of the return of the plaint, and the plaint have been filed according to the order of that appellate court to a proper court which have jurisdiction. But in such a case, the parties are at liberty to raise any objection if they have any. Okay, now coming to the next rule, that is order 7 rule 11, very very important, please keep your bear with you. That is, the plaint shall be rejected in the following cases. When and what are the grounds on which a plaint can be rejected? A, where it does not disclose a cause of action. First of all, plaint which does not disclose a cause of action, it can be rejected, shall be rejected. Okay, it shall be rejected. Now B says where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within the time to be fixed by the court, fails to do so. The plaint is undervalued, it may be intentionally or it may be by mistake, but after finding that the suit is undervalued, the court gave a direction to the plaintiff to correct the error, but the plaintiff is intentionally avoiding or negligently avoiding that correction. Now in such a case, or fails to do so, in such a case the plaint shall be rejected. Now C, where relief claimed is properly valued but the plaint is returned upon paper the plaint is returned upon paper insufficiently stamped. Okay, now stamped duty have not been paid properly. So in such a case, and the plaintiff, on being required by the court to supply the requisite stamp paper within the time fixed by the court, fails to do so. Another case of and after order within the fixed time fails to do the correction. Third one is suit properly valued but the plaint is retained upon paper insufficiently stamped. So in such a case, again negligent and fails to correct the error even after direction from the court and within the fixed time. Now the fourth one is where the suit appears from the statement in the plaint to be barred by any law, where on the face of the record or the from the statements of in the plaint it is evident that the suit is barred by any law. In such a case, the plaint shall be rejected, provided that the time fixed by the court for the correction of the valuation or supply of the requisite stamp paper shall not be extended unless the court, for reasons to be recorded, is satisfied that the plaintiff was prevented by any cause of an exceptional nature from correcting the valuation or supplying the requisite stamp paper, as the case may be, within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff. So the general rule is that when the court directs you to properly, your suit is undervalued and required the court on being required by the court to correct the valuation within the time fixed by the court, and the another case when the suit is properly valued but insufficient stamp paper have been given. Now, in those cases, the fixed time is fixed. That is the general rule. But in exceptional cases, that time can be extended, and where the court is satisfied that the plaintiff was prevented by any cause of exceptional nature from correcting the valuation or supplying the requisite stamp paper, or as the case may be, within the time fixed by the court, and that refusal to extend such time would cause grave injustice to the plaintiff. This is the point, because the court thinks that if that time is not extended, it will be a grave injustice to the plaintiff. So in such a case, that time can also be extended. Now, Rule 12 of Order 7. What is Order 7, Rule 12? Procedure on rejecting plaint. Where the plaint is rejected, the judge shall record an order to that effect with the reason for such order. Okay, so where a plaint is rejected, the judge shall record the reason for such rejection. Now, 13, where rejection of plaint does not preclude presentation of fresh suit. Now, if once a plaint is rejected, is it in such a case, is it what to say? Is it restricting? Is it restricting the plaintiff from filing another suit on the same cause of action? Now, the order Rule 13 of Order 7 says the rejection of the plaint on any of the grounds herein before mentioned shall not of its own force preclude the plaintiff from presenting a fresh plaint in respect of the same cause of action. Okay, it does not preclude. That means include. Okay, he can file a. He can again file a fresh suit on the same cause of action. Now, Order 7 Rule 14 says documents relied on the plaint. Now, production of documents on which plaintiff sues. Now, after the presentation of the plaints and the scrutinization procedure have been properly gone through, now coming production of documents on which plaintiff sues. Now, rules 14 sub rule 1 says where a plaintiff sues upon a document in his possession or power, he shall produce it in court when the plaint is presented, and shall at the same time deliver the document or copy thereof to be filed with the plaint. So, where the plaintiff sues upon a document in his possession or power, he shall produce it in court when the plaint is presented, and shall at the time deliver the document or a copy thereof to be filed with the plaint. Now, 2. List of other documents. Where he relies on any other document, whether in his possession or power or not, as evidence in support of his claim, he shall enter such documents in a list to be added or annexed to the plaint. Okay. Now, 15 says statement in case of documents not in plaintiff's possession or power. Now, in 14 we have dealt with the documents which has been relied upon by the plaintiff and which are in his power. But what about the documents which are not in the power of the or power or custody of the plaintiff? Now, 15 says the statement in case of documents not in plaintiff's possession or power, where any such document is not in the possession or power of the plaintiff, he shall, if possible, state in whose possession or power it is. Now, 16 says suits on lost negotiable instrument. Okay, now if the suit is specifically for the lost negotiable instrument, where the suit is founded upon a negotiable instrument and it is proved that the instrument is lost, and any indemnity is given by the plaintiff to the satisfaction of the court against the claims of any other person upon such instrument, the court may pass such decree as it would have passed if the plaintiff had produced the instrument in court when the plaintiff was presented and had at the same time delivered a copy of the instrument to be filed with the plaintiff. So what has been said here? Where the suit is founded upon a negotiable instrument and it is proved that the instrument is lost, and an indemnity is given by the plaintiff. Plaintiff is giving an indemnity that if my claim is false, I will indemnify the other party. Okay. Now, in such a case, to the satisfaction of the court, against the claim of any other person upon which upon such instrument the court may pass a decree as it would have passed if the plaintiff had produced the instrument in the court when the plaintiff was presented. Court will deem that the instrument have been presented to the court at the first hearing, or with the presentation of the plaintiff. Okay. And in such a manner, if there is any fraudulent activity by the plaintiff, then the plaintiff have already undertaken to indemnify the other party. That is the security to the honorable court. Okay. Now 17, production of shop books. 17.1 says, save in so far as otherwise provided by Bankers Books Evidence Act, where the document on which the plaintiff sues is an entry in shop book or other account in his possession or power, the plaintiff shall produce the book or account at the time of filing of the claim, together with a copy of the entry on which he relies. Okay. Producing the book and the specific entry, and mentioning the specific entry and a copy of that entry. Okay. Have to be filed while presenting the claim along with the claim. Now, original entry to be marked and returned. Okay. The court on or such officer as it appoints in this behalf shall forthwith mark the document for the purpose of identification, and after examining and comparing the copy with the original shall, if it is found correct, certify it to be so and return the book to the plaintiff and cause the copy to be filed. Okay. Now, inadmissibility of document not produced when plain filed. Now, if any document is not produced when the plaintiff is presented or plaintiff is filed, now in a subsequent occasion, one cannot rely on those documents. There are exceptions. We will go through that. Now, Rule 18 sub rule 1 says a document which ought to be produced in court by the plaintiff when the plaintiff is presented, or to be entered in the list to be added or annexed to the plaint, and which is not produced or entered accordingly, shall not, without the leave of the court, be receivable or received in evidence on his behalf at the hearing of the suit. So, if the document is not filed with the plaint, the court will not allow the party to file it at a later stage for the purpose of giving evidence in his favor. The court, you have in generally, the plaintiff will not be allowed, but if the plaintiffs ask for the honorable court's leave and the court grants that leave, then only the document can be taken in as evidence. Now, rule 2 of sub-rule 2 of rule 18 of order 7 says nothing in this rule applies to documents produced for cross-examination of the defendant's witness or in answer to any case set up by the defendant or handed to a witness merely to refresh memory. Now, the above rule is not applicable to a document which is produced for cross-examination of the defendant's witness, or in answer to any case set up by the defendant or handed over to a witness merely to refresh his memory. Now, in such a case, the plaintiff will be allowed to introduce that document. Otherwise, he will have to resort to the leave of the court. Okay. So, this is Order 7 of the Code of Civil Procedure 1908. In our next video, we will discuss about the Order 8, that is dealing with written statement, set off and counterclaim. Okay.